Legislator Bieda.
Present.
Youth Legislator Carver.
Present.
Youth Legislator Chundu, absent, excused. Youth Legislator Craig, she'll be late. Youth Legislator DeVoren.
Present.
Youth Legislator Espinosa de los Monteros.
Present.
Youth Legislator Fournier.
Present.
Youth Legislator Goines.
Present.
Vice Chair Kincaid. Youth Legislator Melendez.
Present.
Youth Legislator Mawasasi.
Present.
Youth Legislator Palmer.
Present.
Youth Legislator Springer.
Present.
Youth Legislator Valenzuela.
Present.
Youth Legislator Wong.
Present.
Chair Haley Meskel.
Present. Thank you, Tina, for calling the roll. Before we start the meeting, I would like to give some housekeeping reminders. I would like to ask everyone to please turn off your cell phones or other devices. Please remember to click unmute when speaking and mute yourself when you are done speaking. Also, please remember to identify yourself for the record when speaking. If you have been identified before you have spoken, there is no need to state your name for the record. Please note that this meeting is being recorded and uploaded to the legislative website. Before we begin, if anyone is prepared to give public comment, please identify yourself now. We ask that public commenters keep your comments to no more than 3 minutes and try to avoid repeating any comments that have been made by a previous speaker. Remember that there will also be another period for public comment at the end of the meeting if you prefer to wait to provide a testimony at that time. Is there anyone who is prepared to give public comment at this time?
Chair, the line is open and working, and there are no callers at this time.
Okay, thank you. It appears that there is no one prepared to give public comment. We will move on to the next portion of this meeting. It is with some regret that I acknowledge that this is our final official meeting of the Nevada Youth Legislature.
Can I interrupt for just a moment? We're having technical problems with our recording, and we need to wait just one moment to, yes, thank you.
No problem.
Oh, it's all fixed. Go on.
Okay, sounds great. It is with regret that I acknowledge that this is our final official meeting for the Nevada Youth Legislature. During this meeting, we will review the bill draft that has been prepared for us by the legal division of the LCB. This is our opportunity to ask any questions and provide any final input concerning the bill draft. Before we get into the discussion about the bill draft, we need to address item number 4 on our agenda. Our last meeting was held on November 19th, 2020. Copies of the minutes of that meeting have been provided to you. I will accept a motion to approve the minutes. Would anyone like to make a motion?
Legislator Fournier, for the record, I move to approve the minutes.
Seconded.
Thank you. Youth Legislator Fournier has moved for approval of the minutes of our last meeting held on November 19th, 2020. Is there a second to the motion?
Youth Legislator Palmer, for the record, I move to second.
Youth Legislator Palmer has seconded the motion. Is there any discussion on the motion or regarding the minutes at this time? I will now take a vote on the motion. When Tina calls your name, please state yes if you agree to the approval of the minutes, or no if you do not agree to the approval of the minutes. Tina, would you please take a roll call vote?
Youth Legislator Abebe. You may need to unmute yourself. Youth Legislator Abebe.
Oh, present, sorry.
Do you vote to approve the minutes?
Yes,
Youth Legislator Atwood.
Yay.
Youth Legislator Bieda.
Yes.
Youth Legislator Carver.
Yes.
Youth Legislator Chundu, absent and excused. Youth Legislator Craig. Has she joined us yet? Okay. Youth Legislator Devoran.
Yes.
Youth Legislator Espinosa de los Monteros.
Yes.
Youth Legislator Fournier.
Sorry, what was that? I was dealing with my mom. One more time.
We are voting about the approval of the minutes.
Yes.
Youth Legislator Goins.
Yes.
Vice Chair Kincaid.
Yes.
Youth Legislator Melendez.
Yes.
Youth Legislator Mawasasi.
Yes.
Youth Legislator Palmer.
Yes.
Youth Legislator Springer.
Yes.
Youth Legislator Valenzuela.
Yes.
Youth Legislator Wong.
Yes.
Chair Haley Misko.
Yes. The motion carries unanimously and the minutes are approved. We will now move on to item number, which is the discussion of our bill draft request, BDR 14549. The bill draft, which has been provided to you all, was prepared by the legal division of the LCB. Asher Killian and Amanda Morancic from the legal division are here to help us with the discussion of the bill draft and answer any questions that we may have. Mr. Killian, would you please give us a brief summary of what is included in our bill drafts?
Thank you, Chair Helen Meskel. This is Asher Killian. I am Committee Counsel for the Youth Legislature and a Chief Deputy in the Legal Division of the Legislative Counsel Bureau. The bill draft before you, numbered BDR 14549, is the current draft of the bill requested by the Youth Legislature for introduction during the 2021 legislative session of the Nevada Legislature. I will just quickly go through the components of the bill, because this may be the first time many youth legislators are seeing a bill draft, and I want to make sure you understand what's on the page in front of you before we get into the substance of the bill. You'll note at the very top of the first page, there is an indication that the bill includes an unfunded mandate not requested by affected local government. This is a flag that the legal division is required to put on any bill that may require spending by a local government that was not originally requested by the local government. Since this is a bill requested by the youth legislature rather than the affected local governments responsible for prosecuting and defending criminal cases, we were required to put this flag on the bill. The next line you'll see is a summary. This is a one-phrase description of the contents of the bill that ends with the BDR number. As you'll see, it establishes provisions relating to the administration of justice. That's the general topic that encapsulates all the contents of the bill. Next, you'll see a section for fiscal notes that indicates that there may be a fiscal impact on local government and that there is a fiscal impact on the state. I'll note that this is a preliminary analysis done by the legal division to determine whether a fiscal impact may be incurred by a local government or the state. Ultimately, this results in the draft of the bill being sent out to the relevant state agencies and local governments for them to provide the legislature with actual fiscal notes describing the costs. It doesn't necessarily mean that there will be a cost. This is just the flag that we use to send it to local governments and affected state agencies to determine what the costs may be. The next chunk of text you'll see is the title of the bill. The Nevada Constitution requires all bills to be about a single subject, and this first clause in the title, an act relating to the administration of justice, is the single subject that encapsulates all the contents of the bill. The following clauses describe with more particularity the various subjects inside the bill, which are all part of the single subject of the administration of justice. Following this chunk of language, you'll see the Legislative Council's digest. This is a couple paragraphs of plain common language prepared by the legal division to describe both the context of the bill and the contents of the bill. The first paragraph describes the background and substance for section 1 of the bill, which is the section relating to training being required for participants in the criminal justice system. And the second paragraph concerns the context and contents of section 2 of the bill, which is the section of the bill that requires the filing of an affidavit containing certain information before a juvenile justice proceeding is commenced. Moving down, you'll see the enacting clause. The Nevada Constitution requires this specific enacting clause that the people of the state of Nevada represented in Senate and Assembly do enact as follows for any law enacted by the state legislature. So the presence of this specific language is required for this law to be given effect. And then following that, you will see the substantive sections of the bill. Section 1 adds a new section of language to Chapter 169 of NRS. Chapter 169 of NRS is the preliminary chapter in the criminal justice title that contains various provisions relating generally to the criminal justice system in the state. This new language added in Section 1, you will see in subsection 1, it generally requires any person involved in the criminal justice system in this state to complete certain training on a periodic basis relating to implicit bias and cultural competency. Subsection 2 of section 1 generally describes what this training must include, including information about implicit bias, information regarding cultural competency, and related background information that may be useful to give this training effect. Subsection 3 of section 1 requires the Attorney General to adopt regulations to carry out the provisions of this section. So those regulations would concern both the contents of the training and the timing and logistics of the training being provided to the various participants in the criminal justice system. And then subsection 4 of section 1 defines cultural competency. We then move down to section 2 of the bill. This adds a new section to Chapter 62C of NRS, which is a chapter dealing generally with the juvenile justice system. Subsection 1 of this section requires as a prerequisite for any juvenile proceeding to begin that the person who files with the court the petition that begins that proceeding to include in that petition an affidavit that certifies that each person involved in the decision to file the petition has received the training required by Section 1, and that the petition is not being filed as a result of any inappropriate discrimination on the basis of any protected class or characteristic. Subsection 2 of Section 2 prohibits a court from accepting any petition to commence a juvenile proceeding that does not include this affidavit. You'll see Section 3 of the bill relating to expenses of local government. This is a technical provision that allows the substantive provisions of the bill to become effective despite the unfunded mandate on local government. And then Section 4 of the bill is the effective date. What this section provides is that sections 1, 2, and 3 become effective immediately upon passage and approval for the purpose of adopting regulations and doing any other necessary preparatory tasks. And then they actually become substantively effective on July 1st of 2022. So that's the entirety of the contents of the bill. If any youth legislators have any questions at this time, we're more than happy to answer them to the best of our ability.
Thank you, Mr. Killian, for your presentation on the bill. If anyone has any questions for Mr. Killian or any comments that they would like to make, please put your name in the chat section. It appears that Youth Legislator Bieda has a question or a comment. You may proceed.
Thank you. So I was looking at one of these sections within the bill draft. I see that we're leaving up the particularities, the trainings to attorney generals, and with the knowledge that they get with the knowledge that they get elected every 4 years around, I'm curious if you think it's better to go ahead and have trainings be decided by a position that has more longevity than from someone who's elected every 4 years, especially since they're deciding certain aspects of these trainings.
Thank you, Madam Chair. Asher Killian, Legal Counsel. So and I'll take this as an opportunity to step back and kind of describe the way the process works from here on out. So this bill is not in final form yet. It has not yet been introduced. During this meeting, the Youth Legislature will decide whether to proceed with the bill in the current form or whether to request any changes to the bill before introduction. If any changes are requested, it'll come back to LCB, we'll draft in those changes, and then that revised bill will be the version that's introduced to the legislature. So Youth Legislator Bieda, you're correct. The bill as currently drafted puts the onus on the Attorney General of the state of Nevada to adopt regulations governing the training process. I believe the intent of that was that since the Attorney General is the chief law enforcement officer of the state, and these provisions generally concern the criminal justice system, that might be the most appropriate party. But in the end, that's a policy decision for the Youth Legislature to make. So if there is an alternative office that the Youth Legislature would prefer to be responsible for adopting these regulations, that's certainly a change that could be made.
Thank you, Mr. Killian. Youth Legislator Carver has a question or a comment. You may proceed at this time.
Thank you, Chair. Alexia Carver for the record. I do have a question on the fiscal note section, so that would be section 3. Do we have an estimated, this is just out of curiosity, is there an estimated fiscal note or would that come on later?
Thank you, Madam Chair. Asher Killian, Legal Counsel. We don't have any information on that at this time. Generally, the rules we use when drafting legislation are if any sort of regulation process is required, that will often cost the agency that's required to adopt the regulations in excess of $2,000. And that's our threshold for whether we flag a bill as potentially having a fiscal effect on the state or not. So since the bill contains a regulatory process, we automatically flag it as potentially having an effect on the state. It would then be sent out to the relevant state agencies and they would return to us fiscal notes for consideration by the legislature describing what they believe the actual costs are. So at this point, the bill hasn't been provided to any affected agencies yet, so we can't know what those costs ultimately might be. Similarly, since various local government bodies, the prosecutors' offices, the public defenders' offices are going to be providing and receiving training pursuant to this bill. That often has some sort of a substantive cost, but again, we can't say with any particularity at this point what it might be. So the bill would be sent out to the affected local governments to return to us a fiscal note stating what they believe it would be. Those fiscal notes are required to be received before the bill is processed by committee in the legislature. So by the time this bill comes up for a committee hearing, we would have those fiscal notes, and those fiscal notes are published on Nellis so that we would have a better idea at that point before the legislature acts as to what the costs might be.
That's really great. Thanks.
Thank you, Mr. Killian. Youth Legislator Bieda has a suggestion, so you can present it at this time.
Okay, thank you, Youth Legislator Bieda for the record. So the main goal of this bill, or at least in some sense, is to go ahead and reduce the amount of discrimination we already have in the justice system. And so when I was looking at the bill, I noticed that we would make available multiple implicit bias trainings. And so I was curious if this idea that I'm about to present might help reduce the cost if there is one. So I was thinking that if reports are made possible or easier at some point in the process that we're establishing here, it might serve it might serve us well to go ahead and make that process easier so we can see if we need a higher frequency of these implicit bias trainings in the first place. Because I assume if we receive less complaints about discrimination in the justice system as a result of, let's say, the first or second implicit bias training, then we may reduce the frequency in which we establish these trainings.
Thank you, Youth Legislator Bieda, for your suggestion. Mr. Keelian, will you be responding to that, or should I go on to the next Youth Legislator?
So I can respond just briefly. I think that's a policy discussion that the Youth Legislature may wish to have. A concept like that, adding in some sort of reporting requirement in statute, is certainly something that would be within the single subject of the bill. So it's something the Youth Legislature could do. That would also, in all likelihood, be germane to the contents of the bill. So that could potentially be an amendment to the bill after the bill is introduced as well. The one other thing that I would point out for the Youth Legislature's awareness is that kind of reporting and reconsideration of timeline is something that is often also done through the regulatory process. So it's entirely possible that the Attorney General, when adopting the regulations to implement this section, could require certain reporting from the various local governments and state agencies, and then revise the timeline that this training is required as a result. The bill doesn't define any particular timeline for the training. It just requires the training to be provided periodically. So the Attorney General, through the regulatory process, would have the ability to say, hey, we're going to start off requiring it once every year. We're going to get some reporting, and then based on the results of that, maybe we bump it down to once every 2 years, once every 4 years. And just so the Youth Legislature is aware, the regulation process comes back before the legislature ultimately. Any state agency that adopts a regulation, before that regulation can become effective, it comes before the Legislative Commission, which is the legislature during the interim, for approval. So there would be further legislative review of any of the regulations that are adopted to implement this bill.
Thank you, Mr. Keelian. Youth Legislator Atwood, you may proceed with your question or comment at this time.
Thank you, Honorable Chair. My question was also in regards to, as was mentioned, the periodic training related to the implicit bias and cultural competency. My question was, would it be perhaps, what's the word? Would it be a bad idea for us to try and, is there to suggest perhaps in, I don't know, the earlier part of the bill, or maybe I was just thinking that periodic seems very vague, and I can understand that for regulatory reasons, but I was wondering if like adding in a provision that would like specify like maybe, you know, you would do training like once a year for a couple of years, and then you would stagger that out, if that would be too rigid of a skeleton to provide for the Attorney General.
And thank you, Madam Chair, Asher Killian, Legal Counsel. That is certainly something that the Youth Legislature could choose to do. That's ultimately a policy question, but from a drafting perspective, we do have language that we would regularly use for that kind of concept. For example, we could provide that the training must be provided once every year unless the Attorney General by regulation allows for it to be provided less frequently, and we could adjust that number to be whatever the Youth Legislature believes is an appropriate starting point. So we do have the capability to provide either a set schedule of timing if the Youth Legislature wishes to include that, or to include a starting point for timing and allow the Attorney General effectively an escape hatch to create a different set of timing, or the bill as presently drafted would just leave it to the discretion of the Attorney General to establish the timing.
Thank you, Mr. Keelian. Are there any other youth legislators with questions or comments regarding the bill draft at this time? If so, please put your name in the chat below so I can call him. It appears that there are no youth legislators with questions or comments at this time. Going along with what Youth Legislator Atwood said, do we discuss his suggestion or do we just go on to approving the bill?
Madam Chair, if I may, Senator Weiner, if I may request of the youth legislators to take just a moment. This bill has another component to it. And this piece that was described by Asher Killian was a consideration that was changed from what was originally discussed in the original proposal. This is a different way of approaching the intent. If you youth legislators, I would humbly request that you take a moment to look at that portion of the bill. It has not been addressed during the conversation, and it is an element that you have not discussed. And I would encourage you to at least review it and determine whether there's clarity around that other part of the bill, which is an affidavit requiring signature, because you have not heard that before, and it did address one of the concerns, but it took a different form in the legislation, the BDR proposed here today. So if you just take a moment and look at it and then determine if you might have questions or thoughts that you might want to share about that portion of the BDR. Thank you very much, Madam Chair.
Thank you, Senator Weiner. I will give you all some time to look over that portion of the bill. Senator Weiner, Youth Legislator Carver asked if someone could clarify the page.
Madam Chair, this is Asher Killian, Legal Counsel for the record, just to jump in. If you look at page 4 of the bill, section 2, this is the section of the bill that requires the filing of an affidavit that effectively inappropriate discrimination did not happen before any juvenile proceeding is instituted. This is the second component of the bill that, as originally requested, this portion of the bill would have required the race of a juvenile to be redacted on any charging or potential charging document presented to a prosecutor's office for a charging decision. Rather than that approach, the approach that was taken after discussion with the relevant parties in drafting was this alternative of requiring the filing of an affidavit that inappropriate discrimination did not happen and the relevant training was completed before any juvenile proceeding can be instituted.
Thank you, Mr. Killian, for clearing that up about the affidavit. Does anyone have any questions regarding the affidavit or what parts got switched out? It appears that no one has questions about that portion. I'm sorry.
Honorable Chair, I believe Youth Legislator Bieda wanted to ask a question.
Youth Legislator Bieda, you may proceed with your question.
Youth Legislator Bieda, for the record. I apologize if you can't hear me well. My Wi-Fi seems to be cutting out a lot. My question is kind of two-pronged. I was wondering whether someone could explain the thought process behind switching the wording of the bill from redacting a juvenile's race on a police report and then moving it over to requiring someone who has gone through a training to go ahead and have an affidavit. That's the first question. And then the second question that I have that can also be addressed is just whether we think simply having someone who's gone through a training and who has signed an affidavit adequately quells the discrimination that we seek to go ahead and minimize.
Thank you, Youth Legislator Bieda, for your question. Senator Wiener, who do you think is best to answer that question? Mr. Killian?
Am I unmuted?
Yes, you are.
Okay, good. I'm having some technical, I'm on my iPad mini. If you would like me to explain the dialogue, Madam Chair, because I was a participant in that conversation? Or would you like Mr. Killian to give that, and then I can kick in any thoughts I might have as to my understanding of the conversation to shift it to the affidavit from the redaction?
That
What
works.
would-
Mr. Killian could explain it, and then
And then I will expand upon that if I feel that there's something that I brought away from that conversation.
Thank you, Madam Chair. Asher Killian, Legal Counsel. And I should have done this at the start, but I'll give our normal disclaimer at this point. Your LCB staff are central nonpartisan staff. We are actually prohibited by law from supporting or opposing any policy position or any provision of legislation. So just as a preface, as nonpartisan staff, it's not my role to support or oppose this bill or any of the policies within it, but just to provide you with neutral, objective advice and drafting services. So my understanding of the reason for the departure from the original request to what's currently been drafted is that after conversations with stakeholders, a couple issues became apparent. One was that race information in a police report is used not only by prosecutors, but also by defense attorneys during the course of a charging decision, largely to establish identification of a potential suspect. And especially on the defense side of that aisle, there was concern that the loss of this information in the police report may make it substantially more difficult for defense attorneys to successfully challenge the identification of potential defendants, which could make it more difficult to defend against juvenile charges if this change was made. The other information that we receive from affected stakeholders, especially police departments, but also prosecution offices, is that there may be practical difficulties in performing this kind of redaction. It's not a function that their offices currently execute, and they worried whether they would be able to successfully implement it, and if so, at what cost. So I believe that's a general summary of the concerns. I'm happy to turn it over to former Senator Wiener now to expand upon that.
Thank you, Mr. Killian, if I may, Madam Chair. And because this was in the charging document, then there was, and we had this during the hearing on the bill, the original early version proposed, and this had been brought during testimony, that this would be at the time of charging, and that information would conceivably or would be expected to be reinstated to the document following that part of the procedure. And one of the concerns was the mechanics and logistics of actually you redact and then you reinstate it into the document. There could be an awful lot of, again, logistical things that could get caught up in that. Information can get lost. Another piece that we had not considered or had not been discussed during the hearing on the measure was how substantial, how this information is very important in both criminal and juvenile justice work that is being done to gather statistics about inequities or biases and other things that such numbers may relate to, that this information is very important. The irony of this in terms of equity, this information is very important to statistically support those arguments if indeed the information would demonstrate inequities, which is what the bill is attempting to address in the juvenile justice system. So this information actually supports the argument that more work needs to be done, and you need to gather the data and statistics in order to make that case. In signing an affidavit, this person or these people would be adding their signature to an official legal document, basically stating, I'm not sure would be considered the level under oath, but it isn't a legal affidavit, signing their names that in no way have they been affected by any of the prejudices that are mentioned in the affidavit, and no biases were components of their decision-making in taking this action step. I would think, I don't know how, Ash may have to answer, Mr. Killian may have to respond to this, but when one signs an affidavit, that becomes a legal document, it becomes part of the record. And if it were determined that there were later, at some point in the process or later, that there had been a form of bias based on the language that this person signed off on in the affidavit, then there would be some measure of accountability, I would believe. That's the weight and power of that signed affidavit. And that was a reason it would create a record that this person stated this, for these people, they would be on record affirming that they were not prejudiced in any way. So that was an intention behind that as well.
And Madam Chair, if you don't mind, I'll just back up former Senator Wiener for a moment there. Taking a step back and looking at what this process generally is, all of these charging decisions and these filings with the court are done by attorneys. All attorneys in the state of Nevada are officers of the court and are liable to the court. We have a duty of candor to the court. And so by placing a requirement upon an attorney to file a document, file an affidavit with the court stating that we did or did not take certain actions, if an attorney were to do that fraudulently, if an attorney were to violate their duty of candor to the tribunal by willfully submitting a false statement by affidavit, not only would that be a massive breach of professional ethics, it would also subject the attorney to potential disbarment and other liabilities. So since all of the participants who would be filing this affidavit are attorneys, that creates a significant measure of accountability for those people involved in this process.
Thank you. Thank you, Senator Wiener and Mr. Killian, for clearing that question up. Youth Legislator Vieta, do you still have your follow-up question?
No, it was answered well. Thank you.
Thank you. Youth Legislator Atwood, you may proceed with your question or comment at this time.
The only question that I was originally going to have was just pursuant to the ability to actually regulate subsection B of the section 1 of section 2, but considering the declarations about how much people would be accountable to that, I don't believe that. My original idea was that would there need to be a way to regulate that subsection B would actually have a mechanism for accountability further than just necessarily just the respectability and the disbarment and the like that you mentioned before. Would there be a person that's in charge of regulating that, or is it just entirely up to the court in that regard?
If I may respond, Madam Chair, and Mr. Killian, please back me up or tell me, oh no, what are you talking about, Senator Wiener? If it is part of the legal history of this proceeding, this is a legal document. It is part of the court record. And if indeed at some point in the process, and I don't know what that extends, how far out it would extend above and beyond, if indeed there were a challenge by the person being charged, that these documents are legal and public documents, that counsel for that defendant, if that person did indeed feel there was a prejudice or a bias, that this document would be a signed affidavit declaring that there wasn't. And so there could be a level of accountability that a defense attorney could use if indeed that person could prove rather that there was a bias or a prejudice, and this document, though signed, said there wasn't, and the attorney can prove that there was, then that would be something that the courts would have to consider. Mr. Killian.
Thank you, former Senator Wiener, and thank you, Madam Chair. And that's correct. The filing of this affidavit becomes a condition precedent to the filing of a petition to institute a juvenile justice proceeding. So if the affidavit was filed falsely, if the training hadn't actually been completed, or if discrimination was part of the basis for the filing of the document, either the defense attorney at trial or on subsequent appeal could raise that failure to satisfy a condition precedent to filing the action to attack the validity of the action of itself and potentially overturn the action itself. It would create a new basis to challenge such a proceeding if this condition precedent were not satisfied.
Thank you, Senator Wiener and Mr. Killian. Youth Legislator Atwood, you may have your follow-up at this time.
Thank you, Honorable Chair. Youth Legislator Atwood for the record. Sorry, I haven't been saying that. The second thing that was on my mind that came up after that, and I would hate to play devil's advocate, but I'm more just I just want to understand more about the process. How easy then would it be? Because if you're saying that, you know, an attorney could even face disbarment if they didn't sign it, if they signed this affidavit and it was later proved to be false. My question is, how easy would it be in most situations to be able to prove that there was inappropriate discrimination based upon the wording in our bill? In that regard, in just after, you know, the process, how easy would it be able to prove that? And how many attorneys might therefore, how easy would it even be for an attorney, for that matter, even working with an officer, to be able to prove themselves that they can prove that that affidavit is true? I just want to understand more about the process if possible.
Thank you, Madam Chair. Asher Killian, legal counsel. I think probably the best way to answer that is to take a step back and describe how legal proceedings generally work in Nevada and in America in general. We have an adversarial legal system. For every case, there are parties representing opposing sides, and it's the responsibility of the attorney for each side to zealously advocate for their client and to challenge the case presented by the other side. So fundamentally, within our legal system, it would be the responsibility of the opposing party to perform any necessary discovery, make any necessary arguments, file any necessary complaints to challenge the other side on these provisions. And it would ultimately be up to the court hearing the case and up to the state bar and the Supreme Court on any issue of attorney discipline to decide whether sufficient facts have been established and whether discipline should ensue. It's kind of a difficult question to answer in the abstract because ultimately each of these will be a fact-specific issue, and it will depend entirely on what is able to be established on the record before the tribunal.
Thank you. Sorry if my question was a little idiotic in one way or another.
Not at all, Youth Legislator. That's I love any opportunity to help explain our legal system and advertise it to brilliant young minds who may someday become my colleagues.
Thank you, Youth Legislator Atwood, as well as Mr. Killian. Next, Youth Legislator Moassasi has a comment or a question that she would like to give. You may proceed.
Thank you, Madam Chair. Youth Legislator Moassasi. I just have a question for Mr. Killian. So in section 1 and subsection 3, it says that the Attorney General shall adopt regulations to carry out the provisions of this section. And so I just want clarification. Does this mean that the Attorney General will also, or the Attorney General's office will also be producing, so they'll be implementing these trainings, but will they be producing the information that we put in the section above? And I guess if so, should it be like stated in there that they're going to be producing this information? And then if not, like if it's another office that's going to be producing this information for the Attorney General to implement, for the people to be required to take, should that also be stated in here? I guess, sorry, that was a little bit of a confusing question, but.
You're good. Thank you, Madam Chair, Asher Killian, legal counsel. So the way that the section has been drafted at this point, the Attorney General has broad discretion. The Attorney General's office could, through the regulatory process, choose to create these materials, provide this training itself. It could also adopt by a reference materials produced by some other body. Effectively, as currently drafted, the Attorney General's office has the maximum possible discretion in that area. The bill would establish certain guidelines for what the topics that the training has to cover. But the actual contents of the training, the actual parties that are producing the training, the Attorney General would have the discretion to decide whether to do that itself or what the appropriate parties or content would be during the regulatory process.
Thank you, Youth Legislator Mawasasi, for your question, and thank you, Mr. Killian, for answering it. Next Youth Legislator that has a question or a comment is Youth Legislator Wong, and you may give your question or comment at this time.
Youth Legislator Wong for the record. This is a question for Mr. Killian. So as clarification, I know you said attorneys could face consequences like disbarment. Is it only attorneys who will sign the affidavit, or does this include anyone involved, like police officers?
Thank you, Madam Chair. Asher Killian, Legal Counsel. Sorry, I just got a pop-up asking me whether I wanted to unmute myself, and I thought I already had. So hopefully my identification was clear. So the way that Section 2 is written, the responsibility to file the affidavit falls upon the person who files with the court the petition to initiate the juvenile proceeding. To my knowledge, and a subject matter expert may be able to provide better advice in this regard, but to my knowledge, the person filing with the court the petition is, if not always, almost always an attorney, because generally to file a petition to initiate a proceeding, you would have to be admitted to practice before the court.
Thank you, Mr. Thank you, Mr. Wong. Thank you, Youth Legislator Wong, for your question as well. Are there any other questions or comments that any youth legislator would like to make at this time? Or are there any names that I missed in the chat? If so, Senator Wiener.
Thank you. My iPad, and I thank you for indulging me. It's so difficult to get to the iPad and work off of my phone reading the bill and everything. So thank you for indulging me in my slow competency with technology. If you look at the bill, there was a question about who will determine the specifics in the training, what kind of latitude in designing the curriculum itself the Attorney General might have. If you look at youth legislators, I will ask you to look, again, it's in Section 1, number 2. The language reads, the training required by subsection 1 must include, here's the important language in this, without limitation, instruction that. So what follows are the specifics that you, as a youth legislature, so take a look at that language, what you are asking to be included in the curriculum. That is what you certainly, as a youth legislator, if those are the pieces you want to be taught, for sure. These are certain pieces that have to be taught, components addressed. That's in the statute, if indeed it passes. That will be a requirement. In that sentence above that says without limitation, that gives the Attorney General discretion to add more to it at the discretion of the AG or different AGs, as we heard earlier, over a period of time. The way it's structured, that what's in the bill, the language of what's required, will have to be included. The without limitation allows discretion to add additional components. Is that correct, Mr. Killian?
Thank you, Madam Chair. Former Senator Wiener, that's correct. The including without limitation language makes this not an exhaustive list. Effectively, the paragraphs A, B, and C that follow are established as minimum requirements, but the Attorney General, as the officer made responsible for implementing this section, is given the power to add additional requirements above and beyond those minimums.
Thank you, Mr. Killian. I have a question regarding the affidavit for Mr. Killian, if that's okay. I was just wondering, I understand that the affidavit will hold the legal team accountable, but is there a portion of the bill that states that if they do not sign the affidavit, that they cannot continue with like the justice system process? Like that states that it's mandatory for the affidavit to be signed in order for them to continue within the justice system.
Thank you, Madam Chair. Asher Killian, Legal Counsel. So effectively, the question you're asking is whether the requirement to file an affidavit has any teeth. And the teeth are in subsection 2 of section 2. So subsection 1 establishes the requirement. Subsection 2 is the provision that prohibits a court from accepting a petition to commence a juvenile proceeding unless the affidavit has been filed. So section 1 creates the requirement, and section 2 prohibits the person from even making it into the court system unless the affidavit has been properly filed.
Okay, thank you. And one last question that I have is the legal team the one that's going to be making the wording for the affidavit, like stating that there's no discrimination that was used, or is their office going to be making the affidavit as well as signing it, if that makes sense?
Thank you, Madam Chair. Asher Killian, Legal Counsel. So there are two different answers to that question. The first is, in order for the affidavit to comply with the statutory requirement, it would have to contain at least the substance in statute. So they would have to certify the statements in paragraph A and paragraph B of subsection 1. There theoretically would be some freedom for the various offices to create their own versions of the affidavit. And this leads to the second answer, which is just practically, in all likelihood, there will become a common form for this affidavit that offices throughout the state will use, just because there's enough to do in the legal process and lawyers don't like to recreate the wheel when we can avoid it.
Thank you. Are there any other youth legislators that have any questions about the bill draft or any comments that they would like to make at this time? Youth Legislator Atwood, you may proceed with your question or comment.
Thank you, Honorable Chair. This is Youth Legislator Atwood for the record. My consideration was for subsection 4 for section 1, does all of the considerations of the understanding, everything from, the cultural, economic statuses, race, religion, does all of that work in with subsection B, subsection 2? Does that work, the definition of cultural competency that we're providing, does all of the statuses and considerations there also work with the consideration after the provides information regarding cultural competency, including without limitation sensitivity to? Or would that need to be added, some of that, into section B? Because another consideration might be, I think, important after that sensitivity to be religion, particularly with Muslim minorities in the country that have often been discriminated against because of events overseas and on the homeland.
Madam Chair, Senator Wiener, if I may respond. Actually, there is a reference to religion in sub 4 that is included in the list. Mr. Killian, there could be in the affidavit whatever language, and then as required in NRS chapter blah, 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 and then all that language would be included rather than being all of it put into the affidavit. Could it not be referenced to a law and a chapter and a section of law that would be all included? Plus, if it were ever amended, you've got to constantly amend the affidavit. So is that a possible way that sometimes affidavits as required under NRS, blah, blah, whatever it would be, and then that section is already in statute, and that would be referenced in the affidavit without reciting the entire section of law?
Thank you, Madam Chair. Asher Killian, Legal Counsel, to respond to former Senator Wiener's question. That's generally how affidavits are crafted. It would probably contain just the language of section 2, subsection 1, paragraphs A and B. So just those two short statements, and then likely a reference back to these sections of NRS to avoid duplicating the language, because the courts, I mean, much like anyone else, don't like to have voluminous, unnecessary language. So the affidavit would probably be relatively brief. And then to refer back to Youth Legislator Atwood's original question, the language in subsection 4 of section 1 is a definition of the term cultural competency. So everything listed in that subsection is included when we use the term cultural competency. And if you then look back to subsection 2, paragraph B, the training is required to provide information regarding cultural competency. So that would include everything in subsection 4, including, among other things, different religions, et cetera. And then the language following that, the including without limitation, sensitivity to the needs of children, et cetera, those are additional items that may or may not be already included within the definition of cultural competency, but that are being highlighted by the youth legislature and law as particular areas of emphasis. Again, that including without limitation construction, that just establishes a minimum. It makes it makes it not an exhaustive list. So everything within the definition of cultural competency, in addition to those items, would be required to be included. And then any other relevant items could also be included because of the use of the including without limitation construction.
Thank you, Youth Legislator Atwood, for your question, and thank you, Mr. Killian. Youth Legislator Vieta, you may proceed with your question or comment at this time.
I thank the chair, Youth Legislator Vieta, for the record. In an effort to make trainings more consistent, I believe it might be a good idea to go ahead and add to the bill draft that the Attorney General might have to consult the rest of the Attorney General leadership, which could include or not be limited to the Solicitor General, the General Counsel, and whoever else we deem as appropriate within that leadership team. But this is just a suggestion.
Thank you for your suggestion, Youth Legislator Vieta. Mr. Killian, what do you think?
Thank you, Madam Chair. Asher Killian, Legal Counsel. That's certainly a construct we could include. I think that's at its core a policy question that would be up to the youth legislature to discuss. Generally, when we in statute cite to the top official within a department, we do that to put the obligation to act on the chief of the relevant office, but that in no way precludes them from consulting with their staff to develop the best possible recommendation. And I mean, quite frankly, frequently they do. So we certainly could include language requiring the Attorney General to consult with any other entities, be it Solicitor General, General Counsel within their own staff, or the Council for Prosecuting Attorneys, or any other external body. But ultimately, that's a policy question for the youth legislature to consider.
Thank you, Mr. Killian. Youth Legislator Vieta, you may proceed with your follow-up.
Madam Chair, Senator Weiner, if I just may add to Mr. Killian before Youth Legislator Vieta, as Youth Legislator Vieta said, maybe making it optional or making the suggestion. Mr. Killian had referenced that we could require. There's also in between, and this is maybe making it's an in between, as I say. That would be if in statute language that might be that encouraging nudge, a recommendation, but not a requirement. There could be permissive language. The Attorney General may consult with blah, 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 the Solicitor General, blah, 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 which isn't a requirement, but if it's put there, it shows an intention that you would encourage them to reach out to others. Does that make sense, Mr. Killian?
Thank you, Madam Chair. In response to, Asher Killian, Legal Counsel, in response to former Senator Weiner. That's another kind of construction we could use. We could break down subsection 3 effectively into two components. One would be authorizing the Attorney General to consult with other relevant parties before making any decisions for the implementation of the section, and then requiring the Attorney General to adopt regulations implementing the section. That's another kind of construction that's used in NRS. And just as your legal staff, what I would ask is, if you want to go down that road, it would be helpful for us to know what other parties you want for them to consult, if there are particular parties you're wanting to name, and if not, we could draft it just as a general statement that the Attorney General may consult with any other appropriate parties to determine the appropriate method for implementing the provisions of this section.
Thank you, Senator Wiener, and thank you, Mr. Killian. Youth Legislator Bieda, you may give your follow-up at this time. Really quickly, I would just like to encourage any other youth legislators. If you have any comments or questions, please put your name in the chat below. Feel free to do so. Youth Legislator Bieda, you may give your comment at this time.
Youth Legislator Bieda, for the record. At the moment, I do think that permissive language would be a good idea to include in this bill. I do like the idea of an optional avenue for the Attorney General to take to go ahead and discuss with the rest of his leadership. As for other leadership that the Attorney General may consult, although I can't name any specific departments or positions right now, I think generally someone who oversees this process in particular closely, and by this process I'm referring to the results we see with the affidavits, for example, that might be a good idea, although I'm not entirely sure at the moment. And secondly, I did just also want to provide some clarification because I thought that the urgency to act is a good idea. Like I was fine with the idea of having the Attorney General do it. I was just concerned about the time frame we see Attorney Generals occupy their office, which is every 4 years. I just thought that the policies we go ahead and see implemented with trainings might be more consistent and then might save us some money if it costs money, if they went ahead and consulted their team, just so we can make sure that the differences between differences between people who are in the position of Attorney General aren't that massive. So that's it. It's not really a question. I just wanted to provide some of what I was thinking. Thank you.
Thank you for your insight, Youth Legislator Bieda. Is there any other youth legislator that has any questions or any comments at this time? If so, I invite you to put your name in the chat at this time. Okay, it appears that there is no youth legislator that, oh, Senator Wiener. Do you have something? No? Senator Wiener, oh, she says no. Okay, I'm sorry. I cannot see anybody for some reason. But if there is no further questions, I will now entertain a motion to approve the bill draft. Would someone like to make the motion at this time?
Youth Legislator Palmer, for the record, I make for the motion to approve this bill draft.
Thank you, Youth Legislator Palmer. I'm sorry. Has moved to accept the bill draft as presented. Is there a second motion?
Youth Legislator Bieda, for the record, I second the motion.
Thank you, Youth Legislator Bieda. Youth Legislator Bieda has seconded the motion. Do the members wish to have a discussion concerning the motion? Senator Wiener.
Yes, Madam Chair, under discussion, before you take a vote, this is the process, this is the time. The motion has been made to approve the BDR as presented. There's been an awful lot of discussion and curiosity and sort of proposals for language during this conversation. The motion and the second that have been made are being made to approve it as exactly as it has been submitted to you by this extraordinarily capable legal division of the LCB, which means that though you've had all this discussion and some of these suggestions about language, what you're voting on right now doesn't include any changes at all. It's what you were sent. So I'm not cheerleading either way. I just want the members to know that there have been no amendments that have been offered for the measure, because if there were, then you would be voting on the amendment and then the measure, and Asher can help with the legality there. But I just want you to be very clear if indeed if there's a member who isn't comfortable with this and there's something else that you feel needs to be adjusted in the measure, then you would, oh boy, I don't remember all the legalities, make a motion to, or ask the maker of the motion to rescind the motion and the second on that rescind, if indeed it's important to add any amendatory, because this is not a final measure right now. If there are changes to make by the NYL, now is the time. If there are tweaks, now is the time. Because right now you're voting on this extraordinary drafting piece in front of you. If you have major concerns about anything that you've been discussing for the past hour or more, now is the time to determine whether or not you want that to be addressed in this measure. Thank you. Thank you. Is that right, Asher? Am I on board on that one?
And thank you, Madam Chair. I'll chime in just quickly to follow Senator Wiener's discussion there. So ordinarily, the way that this would happen during a legislative meeting during session is a motion would be made to either approve the item as is, or a motion would be made to approve the item with certain amendments. I'm just going to suggest as your staff, for efficiency's sake and for the sake of ease of discussion, rather than necessarily following that model, it might be better for the youth legislature to discuss in concept any of the amendments that the youth legislature may want to make separately and vote on those amendments separately. And then once we know which amendments to include, the youth legislature could then accept a final motion on approving the BDR with those amendments.
Okay, thank you. So to my understanding, the permissive language that we discussed about by motioning to approve the BDR as it is, we're not adding that into it? No, okay.
That's correct, Madam Chair. As it stands, the motion would be to approve, or the motion that's been moved would be to approve the BDR as it currently exists.
Okay, thank you, Senator Wiener, and thank you, Mr. Killian. Youth Legislator Vieta has put in the chat that she rescinds to second her motion. Would you like this? You can say it out loud.
Youth Legislator Vieta, for the record, it was my misunderstanding. I want to go ahead and rescind my second to the motion so we can go ahead and discuss amendments.
Madam Chair, you also need the maker of the motion to rescind before the motion is off the table.
Okay. Youth Legislator Palmer.
Youth Legislator Palmer, I rescind my motion too. Sorry, guys.
Thank you, Youth Legislator Palmer, and thank you, Youth Legislator Vieta. Youth Legislator Melendez states that she believes the current language of the bill is the most appropriate. The AG will consult with their team regardless of whether or not we include that detail. As Mr. Killian mentioned earlier, we can have a discussion about that. Youth Legislator Vieta.
Youth Legislator Vieta, for the record, although I mostly agree with what Youth Legislator Melendez is saying, I do believe it's a really good safety measure to go ahead and include that permissive language that at least gives them the legal suggestion that they should consult with their team if they think it's something that's a good idea. I won't say anything further, actually. I still do believe it's a good idea to include that permissive language.
Thank you, Youth Legislator Vieta. Would we like to maybe have a vote on it?
Youth Legislator Vieta, Senator Wiener, Youth Legislator Vieta could offer this as a mandatory language to the bill. The youth legislators could vote on the amendment as the amendment to be added, and then if it passes, then you would vote on the bill as amended. Is that right, Mr. Killian?
Thank you, Madam Chair. In response to former Senator Wiener, I believe that would probably be the most efficient process. My understanding from the discussion so far has been that there have generally been two potential amendments discussed. One is this concept of adding in consultation. The other was the concept of adding in particular timing, and it might be the most efficient way to proceed. If you want to open discussion on one of those, vote on whether to include it or not, open discussion on the other, vote on whether to include it or not, and then make a final motion to approve the BDR, including whichever amendments, if any, were approved.
Thank you, Mr. Killian. And you stated the other motion was adding in timing. Is by adding in timing, do you mean adding in timing for the training to make it more specific?
Thank you, Madam Chair. Asher Killian, Legal Counsel. Yes, I believe that the discussion was about whether to require the training under Section 1 to be provided at certain periods, subject to different requirements provided by regulation by the Attorney General.
Thank you. Sorry. Youth Legislator Bieda, do you have a comment to make?
Youth Legislator Bieda. At the moment I sent that, no, because that was my motion, but I could also add something else. This has to do with the timing of the trainings that that people who are in the justice system would be taking. Oh goodness, let me just remember what I was wanting to say for a moment. I'm sorry, I seem to have forgotten, but if I remember, I'll go ahead and put it back up. Thank you.
Thank you, Youth Legislator Bieda. Youth Legislator Carver, you may proceed with your comment at this time.
Thank you, Madam Chair. This is Youth Legislator Carver for the record. Correct me if I'm wrong, Mr. Killian, but what you're saying is that we have two issues that we want to address with the wording of our bill, and we should do those separately. We should vote on those separately, not as one cumulative wording change, right?
Madam Chair, Asher Killian, Legal Counsel for the record. That's correct. I think the most efficient way to proceed would be to vote on, or to discuss and then vote on each of those potential amendments. And then once we know which amendments, if any, the body supports, we would have a final vote on the BDR, including whichever amendments the body supports.
Thank you,
Thank you, Mr. Killian.
Thank you, Youth Legislator Carver as well. Youth Legislator Atwood, you may proceed with your question or comment at this time.
Thank you, Honorable Chair. Youth Legislator Atwood for the record. In addition to the suggested two considerations for amendments, I understand it might be considered to be a smaller amendment, but in consideration to paragraph B of subsection 2, if the such as sensitivity to the needs of and that which and goes throughout the rest of the paragraph is an attempt to highlight the concerns of those individuals, I would suggest religious minorities would also be another important thing. I believe that recent data has shown that, for instance, for Jewish individuals, there's been a massive increase of anti-Semitic hate crimes across the nation. Also, and then for that matter, hate crimes against Muslims has been high for decades at this point. So I would just say that perhaps a good amendment might be in an effort by this organization to highlight the concerns of many religious minorities across the state of Nevada would be to add religious minorities in the highlighting thereof to paragraph B, subsection 2 of section 1. Thank you.
Thank you, Youth Legislator Atwood. I just have a quick question. I had originally believed that religion was in the in one of the requirements for the affidavit. Was I wrong?
Honorable Chair, that is correct that it is under section 4, but my consideration was that if what we were talking about before of paragraph B subsection 2 is an attempt to highlight particular concerns, then that was just my suggestion for the amendment to highlight, therefore, as well, not to the detriment of any of the other considerations in subsection 4, but just to particularly give a highlight to religious minorities in the state of Nevada.
Thank you. I understand now. Youth Legislator Bieda, you may now proceed with your comment.
Youth Legislator Bieda, for the record, concerning the amendment about the trainings that I meant to comment on earlier, I am just wondering if it's a good idea to go ahead and vote on that amendment at present, because the bill draft as we're presented says that, or the bill draft and the council we have here today say that we're uncertain about any costs arising. But I think if any costs would arise from this specific amendment to the bill draft, we probably should know that before we go ahead and vote on that amendment, especially considering we now introduced this idea that we would do a little bit more reporting than was previously done, or that we would pay attention a little bit more to it. So I'm just unsure and would like to hear from our legal counsel here today if we think it's a good idea to move on with that motion, or with that amendment, pardon.
Thank you, Madam Chair. Asher Gillian, legal counsel. So taking a step back to address the broader issue, we wouldn't have any information about what the fiscal impacts would be until the bill is actually introduced to the legislature and distributed to the agencies and local governments for them to report their fiscal notes back to us. The fiscal note indication on the bill of it being a possible cost for the local governments and a possible cost to the state won't change as a result of any of the amendments. It may change in degree, but it won't change in its yes or no state. So that's not necessarily a concern that the body needs to worry about at this time, is whether you'd be taking the fiscal note off the bill at this point. My suggestion would be it's probably easiest, and you can vote on them in any order you want, but it would probably be easiest just to consider each of these now 3 potential amendments separately for discussion and vote, and then we can move ahead to approve the final bill with whichever amendments the body wants to include.
Mr. Killian, do you suggest we discuss each one of the 3 amendments and then, discuss an amendment and then vote on it, and then discuss another one, vote on it, or we discuss all 3 and then vote on all 3 at the same time?
Thank you, Madam Chair. Asher Killian, legal counsel. Yeah, I believe the most efficient thing would be to discuss one amendment and vote on it and then move on to the next, so that you have 3 separate discussion and voting processes before we then move to the bill as a whole.
Okay, thank you, Mr. Killian. Shall we discuss the permissive language at this time so that we can vote on it? Receive the process. I just have a quick question for the legal team. What would be the downside of having the safety measure of saying that adding permissive language and saying that the Attorney General could have other leadership that oversees the process if he would like, or like saying that they may consult with other parties instead of forcing them?
Thank you, Madam Chair. Asher Killian, legal counsel. I don't foresee any negative consequences of adding that kind of language. It's likely something that's a pre-existing implicit power of the Attorney General as the head of the Attorney General's office to consult with any relevant staff. But explicitly acknowledging that in statute, I don't think that creates any negative effects. It would simply be a recognition of what is probably an existing right in a method that would call to the attention of the reader the existence of that implicit power.
Thank you, Mr. Killian. Are there any youth legislators at this time that have any questions or comments about adding permissive language into our bill drafts before we vote on it?
Madam Chair, if I may, this is Senator Weiner. Just for clarity, for the record, are you asking for a motion to include permissive language for the Attorney General to include other parties in the drafting of anything that might be required under this statute or something like that? You want to make it kind of clear and then maybe ask for a motion for it so that that person, youth legislator making the motion, knows what it is that they're making a motion for the bill body to process.
Senator Weiner, are we making a motion for it, or are we all voting on it? Like, is Tina going to take roll?
No, each one of these, yes, Madam Chair, you are going to vote because we need to move on. We have a training and we have others participating. I don't want to cut you short, but I want you to be cognizant of the time as well. balancing vote, you could say to the body, to your colleagues, I will entertain a motion to do, and then something very specific. Or you can say, do any of the members of any youth legislators have an amendment to offer to the bill? You can do it and then let that youth legislator frame the language. And then once that proposal has been offered through a motion, I will now entertain a second. Then a youth legislator would second it, then discussion, and then we take the vote, the roll call vote, and then you'll do it for the next amendment, then you'll do it for the next amendment. And however that falls out either way through the vote, then you will take a vote on the NYL bill as amended, and you have already approved the amendments you would like to be included in the final measure.
Thank you. Do any youth legislators at this time want to entertain a motion to explain the amendment about the permissive language at this time?
Do any youth legislators at this time have an amendment? I mean, not official language. Would any youth legislators at this time like to propose an amendment to the NYL BDR 14549? And then you recognize a youth legislator who will propose the language of the amendment that he or she would like to see voted on. That person will propose that, and then is there a second to this motion for an amendment, or a motion on this proposed amendment? There'll be a second likely. If there's not a second, it dies right there. But a second, and then any discussion, just the way you did it earlier on the bill, and then we'll now take a vote on the amendment, and then Tina will do the roll call, and that will determine whether or not the amendment will be added to the BDR as you then later vote on the BDR as amended with the one you're voting on right now, or 3 or 2.
Thank you, Senator Wiener. Do any youth legislators like to propose an amendment for BDR 14549 at this time? Youth Legislator Bieda, you put your name in the chat.
Youth Legislator Bieda, for the record, motion to amend the BDR to include language authorizing the Attorney General to consult with relevant other parties in formulating their regulations.
Thank you, Youth Legislator Bieda. Would any youth legislator like to second that motion at this time? Youth Legislator Atwood, you put your name in the chat. Would you like to second the motion at this time?
Yes, I would like to second it.
Thank you, Youth Legislator Atwood, for seconding the motion. Senator Wiener, I apologize. Is this the time that we vote on it?
Any discussion? Any additional discussion?
Any additional discussion for the motion to amend BDR 14549 at this time? Youth Legislator Carver.
Thank you, Madam Chair. This is Youth Legislator Carver. For the purpose of clarification, we are talking, as Mr. Killian said, about the general attorney's ability to consult with other departments. That's what we're talking about right now, right? Please.
Yes.
You?
Yes, Youth Legislator Carver, that is. Any youth legislators have any discussion at this time? Okay, it appears that there are no names in the chat. Tina, would you please call roll to vote for the amendment?
Youth Legislator Abebe?
Yes.
Youth Legislator Atwood?
Yay.
Youth Legislator Bieda?
Yes.
Youth Legislator Carver?
No.
Legislator Chundu, absent excused. Youth Legislator Craig? Youth Legislator DeVoren? You may need to unmute yourself. Youth Legislator DeVoren?
Is this better?
Yes.
Yes. Okay, yes, thank you.
Youth Legislator, Espinosa de los Monteros has left early. Youth Legislator Fournier?
Yes.
Youth Legislator Goins?
Yes.
Youth Legislator Vice Chair Kincaid?
Yes.
Youth Legislator Melendez?
No.
No? Youth Legislator Mawasasi?
No.
Youth Legislator Palmer?
Yes.
Youth Legislator Springer?
Yes.
Youth Legislator Valenzuela?
No.
Youth Legislator Wong?
Yes.
Chair Miskel?
Yes. Thank you, Tina, for calling roll. Mr. Killian said to the extent it's helpful, the next issue could be called as, would any youth legislator like to mention?
Madam Chair, before you move on, you need to declare the outcome of the vote. Let
Oh.
Tina tell you what the vote was on that so you know whether it passed or not.
There were 11 for it and 4 against it.
Thank you, Tina. So indicates that there were 11 for the amendment and 4 against the amendment. The amendment to be added into BDR 14549 has passed. I'm sorry, I'm reading the chat. Require the training to be completed every, okay. So the next BDR that we will be voting for is.
Madam Chair, for correction, you're not voting on another BDR. If you're considering an additional amendment to the BDR.
Yes, my apologies. The amendment that we will be considering is the adding and timing for the training. So would any youth legislator like to motion the amendment to require the training be completed once every 2 years unless the attorney general provides by regulation for a different timing? Are there any, Senator Wiener, I apologize again. Do we do the motion to move first or the discussion first?
Madam Chair, you've just framed the language of the amendment that is being proposed. Therefore, you would ask for if any youth legislators would make a motion to approve this amendment to the NYL bill. And you wait to see if anyone says yes. And if they do, then you ask, is there a second? They say yes. Is there any additional discussion? And then you'll take the vote after that.
Okay, Senator Wiener, in the chat, Youth Legislator Carver asked, can we discuss, or is there not enough time?
Well, let's be respectful that we do have a training. We have people waiting, but we want this is your bill. So we've got to balance it. We have had some discussion already, but we need to balance it. We can't use our whole time up on this out of respect for those who are waiting to participate, including the Senate Majority Leader. And so anything that needs to be vetted that has not been discussed certainly should be brought forward. That any youth legislator, we don't want to squash you because you might have a question that has not been answered.
Okay, so at this time, are there any youth legislators who would like to give a motion to move forward with the amendment to require the training to be completed once every 2 years unless the Attorney General provides by regulation for different timing? And Youth Legislator Melendez, I saw your name in the chat. Would you like to motion? Would you like to motion the amendment?
Yes, Legislator Melendez for the record. Thank you, Madam Chair. I motion that we accept this amendment that would add timing for when trainings would occur, but it would leave it up to the discretion of the Attorney General.
Thank you, Youth Legislator Melendez.
Madam Chair, if I may, I'm sorry to interrupt, but just for clarity and to help a little bit with language, you would, as chair, you would entertain a motion. And so either a youth legislator, I will make the motion to do X, Y, Z, or I move to do X, Y, Z. Just that's the language. You either make a motion or you move. Thank you.
Okay. Okay, so Youth Legislator Vieta, would you like to make a motion?
I second the motion proposed by Youth Legislator Melendez.
Thank you. Are there any discussions that would like to be made about this amendment to the VDR at this time? Youth Legislator Vieta.
Youth Legislator Vieta, for the record. I'll try and be quick. So I'm just curious if we recognize, or I'm just curious if this training that happens once every 2 years happens at one time or if it's staggered. I think the first part of that may sound kind of odd, especially because our justice system is as big as it is, but I'm just curious if we all recognize that this would probably be staggered over 2 years and then occur once every 2 years, unless of course I'm wrong and the legal counsel would tell me so. Thank you.
Thank you, Madam Chair. Asher Killian, Legal Counsel. My understanding is that this would not be requiring all training to happen at the same point in the 2-year cycle, that the requirement would just be for the relevant personnel to complete the training at least once every 2 years. So it would be a staggered rolling period in which they'd have to complete the training.
Thank you, Mr. Killian. Youth Legislator Carver, do you have a discussion about the amendment?
Thank you, Madam Chair.
Wait,
No, I do not.
Give me
Mr.
1
Killian
second, Madam
answered it.
Chair. Do we have a first and a second, just for clarification?
Oh, Youth
We
Legislator.
have Vieta with second.
Yes.
Thank you.
Melendez. Youth Legislator Carver, I'm sorry, you may proceed.
Thank you, Madam Chair. While Carver for the record. Mr. Killian answered the discussion question that I had before it was brought up because he's psychic. Thank you.
Thank you. The next amendment. Do any youth legislators want to propose an amendment for BDR?
Madam Chair, you need to take a vote.
Vote. Sorry.
We learned together. That's okay.
Tina, would you please take a roll call vote for the amendment?
Youth Legislator Abebe,
Yes.
Youth Legislator Atwood,
Yes.
Youth Legislator Vieta,
Yes.
Youth Legislator Carver,
Yes.
Youth Legislator Chundu, absent excused, Youth Legislator Craig, Youth Legislator DeVoren,
Yes.
Youth Legislator Espinosa de los Monteros, Youth Legislator Fournier,
Yes.
Youth Legislator Goins.
Yes.
I could not hear you.
Can you hear me?
Yes,
Yes.
thank you. Youth Vice Chair Kincaid,
Yes.
Youth Legislator Melendez,
Yes.
Youth Legislator Mawasasi,
Yes.
Youth Legislator Palmer,
Yes.
Youth Legislator Springer,
Yes.
Youth Legislator Valenzuela,
Yes.
Youth Legislator Wong,
Yes.
Chair Haley Meskel.
Yes.
That was a unanimous yes.
Thank you, Tina. Being that we have unanimously voted yes for this amendment will be added to our VDR. The next amendment that we have is regarding the religion. Do any youth legislators like to propose an amendment for the VDR 14549 regarding the religion aspect? Okay. Youth Legislator Atwood, you may proceed.
Thank you, Honorable Chair. Youth Legislator Atwood, for the record. I move to approve an amendment to paragraph B, subsection 2 of section 1 for sensitivity to add in religious minorities in the text.
Okay, thank you, Youth Legislator Atwood. I did not see Mr. Killian's chat. the,
You're good. You're good.
okay. I will now entertain a motion to, I'll now entertain a motion to add that amendment into the BDR. Youth Legislator Bieda.
I would like to say that I second Youth Legislator Atwood's motion.
Okay, thank you. Would Youth Legislator Atwood need to make the motion first, or can we move on?
I believe he
If
just
I-
made his.
If I may, Madam Chair, Asher Killian, Legal Counsel, I believe Youth Legislator Atwood did make the motion, and Youth Legislator Bieda is seconding it.
Okay, thank you. Are there any discussions for this amendment? Youth Legislator Carver, you may continue with your comment at this time.
Thank you, Madam Chair. Youth Legislator Carver for the record. Isn't religious minority protections already in the wording of the bill, just in a different place, but is already in the bill? And if we were to add religious protections into Section 2, we would also have to add all of like the veterans protections, and I can't remember quite off the top of my head what the other ones were. We would also have to put those ones into Section 2, just from an ethical standpoint. But it's already in the bill. It's just in a different place, yeah? Please correct me if I'm wrong, but that's my thinking on this. Thank you.
Madam Chair, if I may, Asher Killian, Legal Counsel. I believe the most appropriate answer to this question is that religious minorities, like several other categories of persons, are included within the cultural competency definition. But the language in paragraph B calls out particular people that are included within that definition as a point of emphasis. So specifically children, LGBT persons, racial and ethnic minorities, and women. And so this amendment would just be adding a fifth category that's specifically called out alongside children, LGBT persons, racial and ethnic minorities, and women. And that fifth category that's specifically called out, so as a specific point of emphasis, would be religious minorities.
All right, thank you, Mr. Killian.
Thank you, Mr. Killian, for your explanation. Youth Legislator Atwood, you may proceed.
Thank you, Honorable Chair. Youth Legislator Atwood for the record. Just for a clarification, what we do have in Section 4 is that it mentions all religions. My suggestion is for religious minorities, as Asher Killian specified. And thank you, Youth Legislator Carver. That was the thought that also came into my mind, would be the ethical concern. But I think that since Section 4 says religions in general, but we can also say under Section B, religious minorities in particular, not for any amount of detriment to any of the other individuals under Section 4, but just as Mr. Killian said, just another point of emphasis on particularly religious minorities in the state.
Thank you, Youth Legislator Atwood. Seeing that there are no more discussion questions. Okay, Youth Legislator Melendez, you may proceed with your question.
Thank you, Chair. Youth Legislator Melendez for the record. This was more so a question for Youth Legislator Atwood. In the section where it says racial and ethnic minorities, you are just proposing that we would say racial, ethnic, and religious minorities, correct?
Yes, that would be correct.
Thank you, Youth Legislator Atwood and Youth Legislator Melendez. Being that there are no more discussion questions, I would like to ask Tina to please call roll so that we could vote on the amendment for BDR 14.
Youth Legislator Abebe?
Yes.
Youth Legislator Atwood?
Yes.
Youth Legislator Bieda?
Yes.
Youth Legislator Carver?
Yes.
Youth Legislator Chundu, absent excused. Youth Legislator Craig? Youth Legislator DeVoren?
Yes.
Youth Legislator Espinosa de los Monteros? Youth Legislator Fournier,
Yes.
Youth Legislator Goins,
Yes.
Youth Legislator Kincaid,
Yes.
Youth Legislator Melendez,
Yes.
Youth Legislator Mawasasi,
Yes.
Youth Legislator Palmer,
Yes.
Youth Legislator Springer,
Yes.
Youth Legislator Valenzuela, Youth Legislator Wong,
Yes.
Chair Haley Meskel.
Yes.
That is a unanimous vote.
Thank you, Tina. Being that the youth legislature has unanimously voted for the amendment, I will now entertain a motion to approve the bill drafts with the amendments that have been made. Would anyone like to make a motion? Youth Legislator Bieda.
Youth Legislator Rieta, for the record, motion to go ahead and approve all three of those amendments that passed to go ahead and be put into the bill draft as we understand it.
Madam Chair, if I may propose some language for Youth Legislator Bieda, that I move to approve the Nevada Youth Legislature BDR 14549 as amended with the three approved amendments or something like that. So you're approving the BDR as amended, as just amended with the three proposed amendments.
Youth Legislator Bieta, for the record, motion to approve of the Nevada Youth Legislature BDR 14549 as amended with the three amendments we voted on.
Thank you, Youth Legislator Vieta. Youth Legislator Wong, you put your name in the chat. Would you like to second the
Legislator
motion?
Wong, for the record, motion seconded.
Thank you. Do the members wish to have, oh, I think we did that already. I'm sorry. The motion carries, the bill drafts with the
Discussion.
Madam Chair,
Any
I
discussion?
apologize.
Oh, okay. Any discussion regarding the motion at this time? Being that there are no discussion, sorry, I can't see the chat now.
Madam Chair,
Youth Legislator Atwood, do you have a comment?
Yes, Madam Chair. Did Senator Wiener want to?
yes, I do. Thank you, Ms. Youth Legislator. Now you will vote on the bill as amended, and now we'll do a roll call. Tina will do the roll call. Now you're voting on the entire package because there has been no discussion. So you will now open the roll for the vote on the bill as amended, or the BDR as amended.
Thank you, Senator Wiener. Youth Legislator Atwood, would you still like to make your discussion point?
Yes, please, Honorable Chair. Sorry, this just came to my mind. Sorry, the Youth Legislator Atwood, for the record, this just came to my mind as I was reading Section 4. Should it be amended that just the addition of sexes? Because from my knowledge, and a lot of, because we do have genders, but I mean, I wouldn't know specifically if the NRS has defines it like sex and gender differently or not. In the 1964 Civil Rights Act, for instance, it mentions sex. So I just mean in the sense of upon precedent, would we also want to add sexes into Section 4 under cultural competency?
Thank you, Youth Legislator, for your suggestion. Youth Legislator Carver, would you like to comment on that?
Thank you, Madam Chair. This is Youth Legislator Carver, for the record. The difference between sex and gender in terms of legislation is a gray area. Adding gender usually covers everything. Sex can oftentimes be discriminatory because textbook definition relies off of biological genitalia, which can be a discriminatory factor, but gender should be safe. I would say that adding sexes is a bit redundant.
Thank you, Youth Legislator Carver. Youth Legislator Atwood, you may proceed with your question.
Sorry, I was just going to respond to her. Thank you very much. I was just curious about what that would mean for specifically language. Sorry.
For language, would Mr. Killian like to answer that question?
Thank you, Madam Chair. Asher Killian, Legal Counsel. As a drafting convention, it's our understanding that gender would be the broader term that would include all possibilities for gender and sex expression. So this, as drafted, would be including the broadest number of people within this definition.
Thank you, Mr. Killian. Thank you, Mr. Atwood, for your suggestion as well. So do we continue to vote on the 3 amendments, or would you still like to make that amendment, Mr. Atwood, Youth Legislator?
Oh, I would rescind that amendment then. Thank you.
Thank you. Being as that there are no more discussions, Tina, would you please call roll so that we could vote to pass the BDR with the 3 amendments that have been made?
Youth Legislator Abebe?
Yes.
Youth Legislator Atwood?
Yes.
Youth Legislator Bieda?
Yes.
Youth Legislator Carver?
Yes.
Youth Legislator Chundu, absent excused. Youth Legislator Craig? Youth Legislator DeVoren?
Yes.
Youth Legislator Espinosa de los Monteros? Youth Legislator Fournier?
Yes.
Youth Legislator Goins?
Yes.
Youth Legislator Kincaid?
Yes.
Youth Legislator Melendez?
Yes.
Youth Legislator Mawasasi?
Yes.
Youth Legislator Palmer?
Yes.
Youth Legislator Springer?
Yes.
Youth Legislator Valenzuela?
Yes.
Youth Legislator Wong?
Yes.
Chair Haley Meskel?
Yes.
That is another anonymous, unanimous vote.
Thank you, Tina. Being that the motion has carried unanimously, the bill draft will be revised to the 3 amendments that we have voted on. Hearing that there are no other motions, I will ask Mr. Killian and Ms. Moranicik to please submit these changes to the LCB legal divisions to be incorporated into the bill draft. When our bill is heard during the 2021 legislative session, we will have the opportunity to testify, and I plan to testify during the hearing on this bill. Next is agenda item 6, which is the selection of a member of the Nevada Youth Legislature to consult with the Nevada Association of Student Councils concerning the nomination of a student member to the State Board of Education. As you may all recall from when we did this back in February, one member was appointed to the Nevada State Board of Education, which is a student enrolled in a public school in Nevada. Although the student member cannot vote, the student attends meetings of the State Board of Education and has the opportunity to participate in and ask questions at these meetings. At its meetings, the State Board of Education makes various decisions about education policy in Nevada. It selects textbooks, creates the standards for the state testing programs, determines courses of study, and makes other rules related to education. Therefore, the student member will have the opportunity to present the student perspective to the board during its deliberations. The law requires this student member to be nominated by the Nevada Association of Student Councils in consultation with the Nevada Youth Legislature. The selection of the student member of the state board won't occur until March. So at this point, we do not yet have any information on the students to be considered for the nomination. Additionally, since this is our last meeting, we will not meet again before the selection of the nominee. Therefore, it was suggested that we appoint a member to attend the NASC meeting and consult with the NASC on our behalf, either in person or remotely, as we did last year. The NASC board meeting will probably be on March 6th and or 7th, 2021. Again, our representative may attend the meeting in person or via video conference. Would anyone like to volunteer to attend the March meeting of the NASC and consult with the NASC regarding the nomination of a student to serve on the State Board of Education? Youth Legislator Carver, I see your name in the chat.
Thank you, Madam Chair. As some of you probably remember, this is Legislator Carver for the record. I was one of the members last year that was part of the deciding committee, and I had so much fun, and it was so great, and I'd love to volunteer again this year for this sort of session. But
thank you, Youth Legislator Carver. Tina, would you like to say something?
NASC meeting will be via Zoom this year.
Yes. Okay, thank you, Tina. Are there any youth legislators who would like to attend the March meeting? If
Madam
so,
Chair, at this time, just for clarity, you have Youth Legislator Carver who's volunteered to do it a second time. So you would say, are there any others who are interested and would like to be considered? If it's only Youth Legislator Carver, thank you so much for volunteering again. If there are others who are interested, then you would take a vote of the Youth Legislature between the two, and the one who would get the top vote would be the representative.
thank you, Youth Legislator Carver, for volunteering. Is there anyone else who would like to volunteer? Okay, it appears that Youth Legislator Carver is the only one that volunteered. So thank you, Youth Legislator Carver. Since Youth Legislator Carver will be consulting with the NASC on our behalf, we should provide some guidance on the qualities we consider most important in selecting a nominee. For instance, do we want to emphasize leadership experience, academic achievements, or something else entirely? I will open the meeting up for discussion at this point. Any youth legislators who would like to make a comment, I invite you to put your name in the chat. Youth Legislator Goins, you may proceed.
Hello. Last year I applied for the position of student member to the Board of Education, and I was selected as the second runner-up. So I guess kind of the second candidate. So I kind of do have a little bit of experience with this, but I would say that it's really important for the candidate to show an understanding of policy and to show an understanding of, the legislative business that goes on in NASC and in the State Board of Education and just in the Department of Education in general. I know that a lot of candidates who do apply for this position really put emphasis on the fact that it's an NASC position, and they really focus on the fact that it's a student council position. And most of the time, student council members are really focused on certain aspects like enthusiasm and things like that, which is great. But it's really important for this specific student member to the Board of Education to have that understanding of policy. So to Youth Legislator Carver, I would really suggest making sure that the candidate does have an understanding of what goes on in the legislature and what goes on when you're passing bills and all of that sort of business. That's what I believe.
Thank you, Youth Legislator Goins, for your insight. Youth Legislator Wong, you may proceed with any discussion that you may have.
Youth Legislator Wong, for the record, I also agree that a background in policy is needed, specifically education, because of the nature of that position. But I also think that enthusiasm and past work in student council is also very important because, in my opinion, that shows dedication. And so I think those things should also be considered.
Thank you, Youth Legislator Wong, for your insight as well. Youth Legislator Vieta, you may proceed with your discussion.
Youth Legislator Bieta, for the record, I feel like a candidate should have previous exposure to not only their own public school, but also other public schools that are separate to just attending like certain student council conferences. I'm not too versed on what they attend, but I feel like a separate desire to go ahead and expose themselves to other people who may live in different parts of Nevada than themselves and other parts of the valley. Let's say if they live in Vegas, is very important because it shows a commitment to go ahead and understand people who are not at their own school and who are from different backgrounds.
Thank you, Youth Legislator Vieta. Are there anyone else that wants to add their insight or discussion at this time? If any youth legislators would like to do so, I invite you to please put your name in the chat. Youth Legislator Carver, you may proceed.
Thank you, Madam Chair. Youth Legislator Carver, for the record. So I've been taking a few notes, and from the three speakers, I understand, or sorry, four. Yes, four, I can't count, is that the general understanding and the general consensus we've come to is that we want the member to have an understanding of policy and an understanding of the legislative business, but to also be enthusiastic and has a background in this sort of work. And just from the candidates last year, we had 9 candidates, if I remember correctly. There are definitely a few that had that understanding. So I think this is a very doable goal to have a member like this. So, great.
Thank you, Youth Legislator Carver. Seeing as that there are no more youth legislators that put their name in the chat for discussion, I can't read the chat. Is there anyone else that put their name in the chat, because for some reason I can't see it anymore? Seeing as that there's no more discussion, it is to my understanding that we have decided that the qualities we think are important is understanding of policy, understanding of education, having enthusiasm and dedication, as well as previous exposure. I would like to thank everyone for their participation in the discussion. I hope this discussion has been helpful to Youth Legislator Carver in highlighting some of the qualities that we look for in the nominee for the student member of the Board of Education. Since we have no other items to discuss, we will move forward to the next period of public comment at this time. I will now open the next period of public comment. The same rules mentioned during the first period of public comment apply. Please try to avoid repeating the same comments that have been previously made. And I ask you to please limit your testimony to 3 minutes. Is there anyone that would like to make public comment at this time?
Chair, the line is currently open and working, and there are no callers at this time.
Thank you. Seeing as we do not have any people prepared to make public comment at this time, we are now ready to adjourn. Do any members have any final thoughts or comments before adjourning? Okay. Seeing as though there are no discussions, this concludes our business for today. Thank you so much, and this meeting has now been adjourned.